we do need a statement of rights to measure the acts of the executive and, to an extent, the acts of Parliament or the legislature against. But for historical reasons, because we've never developed organically our own Bill of Rights within our own country, dovetailed into our own constitution, legal traditions, historical traditions, we've ended up in 1998 taking in wholesale the external statement of rights contained in the European Convention on Human Rights, and also taking in, to a large extent, with it, the interpretation of those rights, which has been built up over the previous 50 years by the Strasbourg Court, the Court of Human Rights at Strasbourg. And it seems to me, and I think to my fellow colleagues in the majority on the Commission, that it is important for us to move to a position which would be similar to that of the majority of other European states, the majority of other Commonwealth states, of having our own homegrown Bill of Rights, which would be consistent with the European Convention, would cover the various categories of rights which it contains, albeit in different ways, expressed in different forms, and possibly adding rights here and there, like, for example, the right to jury trial, which appears in the Canadian Charter of Rights and Freedoms, can't obviously appear in a European instrument because many countries do not have a jury system at all in criminal trials, but could be usefully incorporated in a British Bill of Rights. So that, if you like, is the main argument. I mean, there are others, but that's the main.
No. Thank you very much for that. Philippe, what's wrong with that? Homegrown rights.
You know, in theory, it's wonderful, but we live in a world that is more complex. When I was appointed to the Commission on the Bill of Rights, I had a completely open mind about the question. I didn't have a strong view one way or the other. I wanted to listen to my colleagues in the Commission. I wanted to participate in the consultations. I wanted to hear from people around the country. If anything, my predisposition was to be rather in favour of a UK Bill of Rights. And I think that probably, in an ideal world, would still be my default or starting position. But, and the but is a series of big ones, the world is not pure in which we live right now. We were given terms of reference, just to come back to that point, which committed us to proceed on the assumption that any UK Bill of Rights would build on an incorporated European Convention on Human Rights. It became very clear early on that that was problematic because a number of members of the Commission had rather negative views towards the European Convention on Human Rights and even more negative views towards the European Court on Human Rights. And when pushed, it became clear that actually at least three of them would like to leave the European Convention on Human Rights as soon as is humanly possible. And against that background, it became very clear to me, and to Helena, because we signed off on a joint separate view, that a Bill of Rights for some, but not for all, was a vehicle for withdrawing from the European Convention on Human Rights. And once that became clear, it was going to be difficult for me to conceive of joining in such a view, largely because I don't accept that the European Convention is the imposition of an external view. I go back to the history. I've just finished writing the introduction to the reissue, which is coming out soon, of Herschel Lauterpacht's book of 1945, A Bill of International Rights, which is really rather remarkable. And when you follow the process after he wrote that book and what happened between 1945 and 1950, and see the role of people like David Maxwell Fyfe and others on the Conservative side, ironically, it was the Labour side that opposed the European Convention on Human Rights, you begin to see how far things have strayed. So that was really the first issue, that the terms of reference, I thought, were not respected in the final majority report. Secondly, the other issue that emerged, and Martin hasn't mentioned it, but I suspect we have very different views about it, although we have different views about how to manage it. The great elephant in the room, that hit me in a way that I had completely not expected: devolution. I thought of the United Kingdom as a single unitary state. It is not anymore a single unitary state. It is a federal structure. We went around the country, and in Wales, we were told very politely by Tory colleagues of the Welsh Assembly, well, I'm a member of the Conservative Party, I've got to say I'm in favour of a Bill of Rights, but actually the truth of it is we're rather happy with the European Convention on Human Rights because we're rather progressive, we like what's in there, and actually, they said rather quietly, we're quite happy with the European Court of Human Rights. In fact, it's better to have these decisions being made in Strasbourg interpreting our laws than a court in London, a Supreme Court on which there's not a single Welsh member. They were polite. In Northern Ireland, you talk about, the word British disappeared. It became a UK Bill of Rights. I need say no more about Northern Ireland. And then we went to Scotland. In the context of the announced referendum, which it was coming, it hadn't yet been announced, that came later. And they basically stuck two fingers up at us. They just said, as one of our nice Scottish members put it, get your tanks off our lawn. We are not interested. We will have our own Bill of Rights. So you immediately get that reaction, and you've got 3 of the 4 countries of the United Kingdom saying, no, we're not interested in a UK Bill of Rights, really. We'll have our own thing, and we're perfectly happy with the status quo. Which leaves the largest of the 4 countries, which of course has no one to speak for it, because there is no English Assembly, no English Parliament. What you have instead is Westminster. So the devolution issue became absolutely central. And it became very clear once the referendum was agreed, there could not be anything else happening.
So what is the way forward?
Well, I mean, there was a consensus. There was quite a lot of consensus, actually, on a whole raft of issues. One of them was that, it was quite significant, was that we should do nothing now. We need to wait until the Scottish referendum, because we're all terrified of Scotland and what will happen. And, of course, it doesn't only depend on a majority for an independent Scotland. If there's a very significant vote for independence, then that will have, plainly, political consequences across the whole of the United Kingdom. And I should say that it was a surprise to me, but it's clear that the Scottish situation is having spin-off consequences in Wales, which has had a green paper on its own judiciary because they're getting increasingly unhappy why they have to go to London to have all their big legal decisions decided. So there's that particular context. So nothing will happen this side of the next general election. I think that what happens thereafter depends on the vote in the general election. I think there is every possibility that the next Conservative manifesto will call for British withdrawal from the European Convention on Human Rights. And I think that the battle lines will then be drawn. It is clear from the reaction of the political community to this report that Labour came out essentially in support of the minority view. Tom McNally, on behalf of, I don't know whether he was speaking on behalf of the Liberal Democrats, but the Minister of Justice, essentially came out in support of the minority view. So you've got a political split. SNP, Plaid Cymru, also very against a UK Bill of Rights. So the only way forward, I think, for a UK Bill of Rights is an outright Tory majority at the next election. Whether that happens or not, is of course not for me to speculate, but I think if that doesn't happen, you won't see a great deal or any change. That is the one way to achieve the nirvana of a UK Bill of Rights in the foreseeable future.
Martin?
Well, I think I broadly agree with Philippe's analysis, although given from a different perspective. Apart from the prediction about withdrawal from the ECHR being a Conservative policy put forward at the next election, I don't know, that might or might not be put forward as a policy. I think even before were adopted as an election manifesto policy rather than a government or parliament policy, it does require a great deal of thought, because there are all sorts of both domestic and indeed international political and legal ramifications of such a step.
I mean, we haven't talked about the international side. I'm glad you mentioned that, because the other side of it is there's a lot of countries watching the United Kingdom. You know, just to give you a separate example, I sit as an arbitrator in ICSID cases, and I had a recent case involving a South American country as a respondent, in which counsel for the claimant against the South American country said at one point in the oral arguments, can you believe it? This country wants to withdraw from the Inter-American Court Convention on Human Rights. And I sat there listening to that argument thinking how extraordinary it is that one of the major political parties of the United Kingdom is on the cusp. I think it's very striking. You didn't exclude the possibility of calling for withdrawal from the European Convention on Human Rights, an instrument that the United Kingdom did more than any other country in the world to put in place, and which I think promotes UK values, promotes the rule of law, and I just think it's amazing that we've got to a point that the Conservative Party could even seriously talk about withdrawal from the convention. I find it astonishing.